give up. Got too little time, I'ma live up. Head down, push forward through the tough times, cause anything worth doing is a tough climb.
Pennsylvania, Mafia rules apply when city officials condemn landlords' properties and hit and run, causing fractures and surgeries. Story continues. P3. Here I want to start out with, I personally do not find law to be a just process. Is it justice when judge's decision takes over 2 years? No. Is it justice when judges throw out some or most of your claims? No. Is it justice when pain and suffering of reliving all pervasively sits with you throughout the process? No. Is it justice when you must experience financial undue hardship just to hold others accountable and get justice? No. Is it justice how much life you must waste to carry out these processes? No. Is it justice the fact the little guy is willfully taken advantage of? No. Is it justice when you are not willfully taken advantage of, but through lack of knowledge you are disadvantaged and unlikely to gain positive outcomes? No. Overall, I start with you should only file suit when issues are pervasive, significant, and severe. Legal processes are in my eyes a waste of life, untimely, and unfair where the little guy always finishes last. This leads me to the intent of this content. I am not a licensed attorney but wish to share a story that you can review, learn from, and gain a more informed perspective so you can take informed actions to have better outcomes in life. Let's continue with the story of events and applicable law here. Be sure to slow the video speed settings if you want to watch the video in a slower pace. Here, a property was condemned and taken from the landlord back in 2014 without fair compensation of the market fair value of the home, and the landlord was forced out of the home before the city had any evidence of any condemnable condition of the home. Yes, Mafia rules apply. Through legal pretext and falsified stories, the city officials were able to get the family forced out of the home, then later completed their inspections for condemnation after the fact months later, when no one was in home to maintain it. Later, city official was terminated for a hit and run where they hit landlord with a truck. Yes, this employee was terminated. Here is the kicker. What about his boss? Nope. The official who personally condemned 2014 property was the supervisor to the hit and run criminal offender. Yes, Mafia rules apply. Broken bones, surgery, and medical appointments and therapy still today for this incident. Does the city care? Nope. This is evident as the story continues. Smash the like button for the YouTube algorithm to supercharge the YouTube algorithm and support me making more content for you. Continue from here. The city dumpster truck hit and run against landlord's newly purchased rental 2-unit property December 20th, 2020. Yes, this type of thing is common in our area. It is common for our city to purposely hit and run fences and accessory walls, knowing that these are structural and may justify cause for the city to condemn a property. Yes, Mafia rules apply. This hit and run against the accessory wall occurred just after the insurance repaired it for a weather incident and just before I began to personally oversee city actions. I began overseeing all because I flew all the way from Saipan, ending my Department of Homeland Security job, where I ensure compliance of environmental laws, regulations, policies, executive orders, and guidance for multi-million-dollar grant projects and perform inspections for these projects. I flew home and began managing repairs for my property, also a rental, September 1st, 2022. Here I learned of an incident where the landlord city official, yes, the supervisor we spoke of above, called and harassed the electrician listed on my permit, although outside of his jurisdiction in a city 20-minute drive away. From here I sent a letter to his offices clarifying upset and requests for all harassment to stop. Yes, Mafia rules apply. Here I began to oversee landlord city officials' actions. I would document observations by emailing the officials regularly based on all occurring. For example, after inspections, I would research compliance and communicate my findings, as well as repeatedly ask for fair legal actions and processes. All was disregarded. The officials and city attorneys specifically stated within the local city hearing that they do not read emails and disregard them all. Yes, they admit to failure to perform their duties. Yes, Mafia rules apply. In this city, officials can do and say whatever they want. There is no oversight. They can perform numerous inspections and request landlord complete unnecessary maintenance actions or repairs by law. There is no oversight. Willfully, they choose to visit properties frequently but not document all visits with an inspection report. Good luck overseeing what is not documented and is put under the rug for no eyes to see except the landlord themselves. Here landlord and I oversee all.
Continuing on.
City official, yes, the supervisor from above, condemned one of the units of this 2-unit property, May 2022. The second unit was condemned April 20th, 2023. Smash the like button for the YouTube algorithm to supercharge the YouTube algorithm and support me making more content for you. Story Part 2 clarifies my legal and case law review of all, as well as shares photos so you can see our property and come to your own conclusions. Here, we give you new information. No point in repeating ourselves. For this, all 17 Sand Street, 17.5 Sand Street, and 19 East Oak Street were all livable and actively lived in by family with kids, tenant Kayla and tenant Roy and family with kids when they were condemned, and Airbnb March 7th, 2024 receipt further evidences livable condition of home with all essentials amenities and no serious or significant issues. Check out rest of the articles or YouTube videos on this topic and rewatch them as needed. Sorry they may be complex and brief, military veteran brief, but also detailed. Data analyst detailed. Yes, I am a weird find. I am a scientist and technology expert. I shifted into law, compliance, and inspections work. My resume, see Alyssa Mahan VLS on LinkedIn, is rather unique. Let's get to explaining legal processes specific to my city and the upper court, which has a building just 15 minutes away. A common practice by city officials. Do not answer emails and do not answer phones. If you answer phone, avoid answering questions. Common response, we do not give legal advice. The problem is, you, the city clerks and protonotary officials, are legally required to provide documentation or clarify procedures for filing appeals, hearings, civil suit, criminal suit, i.e. clarify publicly available information so individuals can file suits pro se themselves. People have the right to receive publicly available information on processes, so they may file claims and have fair hearings. Landlord City and my own 20 minutes away both fall under the upper-level court where all three withhold information, so individuals do not have fair processes and cannot fairly be heard. They say if you file claims or suit without an attorney, you will likely almost definitely lose. Yes, my wording here is purposeful. I am trying to clarify. You probably have a 2% chance of winning if you go through the processes alone, especially when they are the more complex legal cases. How is law fair when you cannot gain justice without an attorney? I answer, it is not fair. Fairness by definition would mean 50% of individuals without an attorney win their cases. When it comes to procedures, I had to research and ask a lot of questions to get the following understanding. Hopefully you benefit or learn from the following summary, but as a disclosure, I am not an attorney. Attorneys and judges, at least in my area, safeguard information, and I only researched but did not implement this process yet. For real estate citations, the landlord city has no method for submitting evidence before hearings. During hearings, when you are very stressed and a mess, you are expected to communicate your case and submit evidence to the judge. The judge can accept evidence or disregard it and not submit it to record, according to the magistrate office official of the landlord. For the landlord city, the magistrate's office official stated, there is no online portal or email address for evidence submissions. They do not take or accept evidence before hearings. All evidence must be given to the judge within the hearing before exiting the bench or leaving. If the judge does not take or accept evidence, that is up to them. Local magistrate office's phone call. All at this point is clearly unfair anyway. Here is where you appeal unless you are okay with the decision of the judge. In a fair situation, a judge may disregard because it is not relevant or other reason, then make a decision that all parties find reasonable. Overall, the judge in my eyes at this level can apply the law subjectively with little oversight. I asked, how do we file complaints about unlawful words or actions of a judge? No one answers this question. Information is safeguarded. It is as if everyone who is an attorney or judge is taught to withhold information to ensure their job security is maintained while also ensuring they are not held accountable within the legal system. People say, withholding information is a form of lying. This is common practice within the legal systems. There is little or no oversight. Yes, Mafia rules apply. Smash the like button for the YouTube algorithm to supercharge the YouTube algorithm and support me making more content for you. As an aside, for condemnations, you can appeal the determination within a hearing by the local board, but you must pay a steep price of $500, which is insane when you consider the upper-level court fee for a criminal or civil suit is under $180 to file these. Which would you rather? File in a local court to go to local board to clarify how the condemnation is unjust within a biased court within the same buildings as the officials that condemned the property in the first place? Or would you rather file a criminal or civil suit for less money, which may be waived of fee costs if you are low income, then seek justice in an upper-level court which may be more objective or less biased? Then, if you appeal the decision of this judge, the upper-level court can disallow new evidence, which he did for this landlord. The judge here did not let landlord be heard. This is why I wrote this article for you. I do not believe in the fairness of this process and hope to inform others of all in hopes you can be informed and have better outcomes. Yes, Mafia rules apply. Here, the upper-level court literally gave the landlord maximum fines when no boarding house exists at the property and the city officials deemed the property to be livable, occupancy approvable, and not condemned within an inspection report less than 30 days from the issue of contention. Here, landlord can appeal citations, but good luck. I learned after the proceedings, there is actually an e-file system for electric filing of evidence. Wow, if only people are informed. Instead, taken advantage of. You can, if you have low income, you can file paperwork to have hearing costs be waived. Apparently for this filing website, you can search and download records. For our process, each filing must be recorded in separately indexed docket entries and include a certificate of compliance that is attached. Filing fee schedules law out the costs for filing claims. The fees are all to be publicly available. I recommend ensuring you have the clerk's phone number and protonotary number so you can gain clarification on fees and processes. Drafting legal documents. Good luck, as no one will clarify anything for that because they can't give you legal advice. This is the excuse the officials always give any time they do not want to do their job, i.e. talk on the phone. They avoid answering phones, then avoid answering questions, then avoid giving you documents so you do not know procedures that should be publicly available. If you wish to do a civil or criminal suit, I learned that you file with your district court and pay fees, unless the fees are waived. This case will get entered into a system where you will again have access to a filing site. For the Pennsylvania Superior Courts, PacFile is the e-file site. There is to be publicly available information clarifying how to do these processes procedurally. It should tell you how to format documents, what information must be included, and different deadlines. Smash the like button for the YouTube algorithm to supercharge the YouTube algorithm and support me making more content for you. You pay for the lawsuit at the district level based on my findings, and this filing must include a cover sheet, payment, and brief evidence. All of this must have a docket number on the filing documentation. Problem with the electronic filing is that you may need to pay for filing these documents. There are filing fees for these online systems sometimes. Skipping to a less procedural and more legal-related information. You can file a claim due to, for example, due process violations where you argue that the condemnation process violated your due process rights. This could include a lack of proper notice, failure to follow legal procedures, denial of the opportunity to rectify issues, or denial of the opportunity to challenge the condemnation before the condemnation is finalized. Unreasonable delay in lifting condemnation where the condemnation designation was not lifted within a reasonable time after the issues were resolved. The delay's cause of unnecessary harm, particularly if it is impacting the sale of your property. Economic damages where you seek compensation for economic damages caused by the inability to sell the property. This could include lost profits, additional costs incurred due to the delay, and the difference in property value caused by the condemnation. Arbitrary or discriminatory enforcement where similar properties were not condemned or had their condemnation lifted more quickly. You might argue that the enforcement against your property was arbitrary or discriminatory, violating the Equal Protection Clause. This last one is also applicable to the landlord's case. Reality is, I clarified in part 2 of this story that other properties of similar or worse condition are not condemned. Interestingly, the house across the street of landlord's property was condemned. Then the condemnation was lifted in a week or so on or around August 2024. As a draft, and as an example here, I will go into clarifying civil suit claims for relief. Specifically counts 1 to 24 so you can understand what unlawful actions may include and what legal citations or case law may apply to them. Citations may be required by federal, state, or at the local requirements. Normally, you do not really include case law as I did here, but I included it in this order to foster understanding. As summarized, most people do not have all this drafted, and especially to this detail probably. Once you have something figured out and put onto paper, hopefully you have an attorney to file everything, because if you miss one requirement, the whole case may be dropped, lost, or forced to settle to an end. Again, here I wish to clarify, I may have a master's in environmental law and policy from Vermont Law School, but this environmentalist does not believe in the legal system because I have only ever seen law fail to ensure ethical, just, and/or timely outcomes. Yes, my sister who is in law school now specifically said she would never become a lawyer because she did not like how attorneys mistreat people and mishandle cases. I too agree. In addition, I believe that the legal system yields the innocent imprisoned. Great employees fired for whistleblowing. Landlords fined for anything and everything, then manipulated within processes. Food, products, and health organizations are paid off by companies. Climate change or other environmental issues are put under the rug and ignored. Good luck, humanity. There is so much gone wrong or so much to improve upon. War, why are people brainwashed to hurt others? Why is humanity selfish? Humanity is always wanting more, says the Odyssey Greek stories. For me, I do not believe in legal systems being fair. Again, you only live once. Why waste life reliving trauma in a process that will not seek to right wrongs or do so timely? So instead of filing suit tomorrow, although 100% ready to file suit with an understanding of how to file it pro se, I choose to instead report my concerns to the mayor of the landlord city with a city attorney CC'd. You may find this all entertaining as you get to count 23. Review more deeply count 23. Why did I do this? Why did I draft all this legal documentation then chose to not file suit at this time? Smash the like button for the YouTube algorithm. Well, I did clarify in detail why above. Separately, I am choosing this path of not filing suit and instead reporting my concerns to the mayor once again because arguing gets you nowhere. President Abraham Lincoln, or similar words. If you want to be heard, whisper. Here I whisper all in detail in emails. If I was in person, it would be difficult to not get upset when I see wrongdoings and the totality of situations. Instead, I transparently report concerns and request city take actions in compliance from now on. If they fail, next time they take unlawful actions, these actions will be knowingly taken unlawfully. This means they are even more liable. Then also, there is a statute of limitations, so you do not have to file suit today. You can file suits later. Then also, I am the worst at arguing. I can research the Hello Kitty out of anything, but argue is not me. I share information and prefer others come to their own opinions. I am not one to care to argue, or get someone to be on my side. I am not one who flatters. You objectively agree, or you do not. I do not beg. I clarify facts objectively, and let others decide. If you become verbally abusive or unfair, I shut down because I sense things and take things personal. I get stressed and overwhelmed because I see flaws and know I am powerless to the strong perspective of others who will probably stop listening when they disagree. People always want to be right. If you are too different, good luck getting through to these individuals. Here, I chose to email the mayor instead, help the landlord file suit at this time. You may call this email gutsy. You may call this stupidity. Either way, I say, one cannot ensure actions are in compliance if they do not know what things are unlawful. Then once they know what is unlawful, either they take lawful actions from now on knowing they are being watched, or they take unlawful actions willfully and knowingly, which means they will be held more liable if a lawsuit is filed later on. Overall, I say, as Shackleton would say, informed individuals can make the best decisions. In life, choose to be informed. Choose to ensure lawful actions by ensuring others are aware of what is unlawful. Then if they choose unlawful actions knowingly, you at this point should take actions knowing the issues at hand are serious, significant, and knowingly wrong. My email to the mayor. Greetings, Mayor X. I wish to report my concerns and request concerns be addressed to ensure City of X officials implement actions lawfully from now on, as I am very upset and concerned about city officials' actions too. Unlawful take on or around 2014 of 19 East Oak Street property. Unlawful hit and run of truck against landlord causing medical damages. Unlawful hit and run of city dumpster trash truck to accessory wall at 17/17.5 Sand Street. Unlawful take and loss of beneficial use to 17/17.5 Sand Street, etc. While I have sufficient evidence for both criminal and civil lawsuits, as well as so upset as to have drafted the documents for submission, i.e. cover page, exhibits, facts, timelines, damages, etc., I wanted to here clarify the below statutes, ordinances, codes, and standards, etc., breached, and request compliance of these be implemented fairly from now on. These may be some, but not all. Instead, just what I am reporting to you at this time. Mayor X and City Attorney X CC'd. May you ensure the below are implemented in compliance from now on. If you have questions, your city attorney can clarify the below legal information to help you ensure the city actions are lawful from now on. Here I provide very lengthy legal information and case law. End of email here. I then decided to be more gutsy, or more stupid. My next email. Greetings. CC'd City Attorney X. As a third party who owns no properties in this city, I wish to also request you address concerns and ensure City of X compliance for the below claims, counts, statutes, etc. listed below. Remember, audience, I choose to pursue no lawsuit at this time, but can at any time I want. Landlord can also file suit at any time. Continuing with the contents of the second email. Count 1. Unlawful retaliatory violations by law should be against LLC, not the said landlord, because they are a manager, not the actual deeded owner of the property. City officials form violations against landlord when she is not the owner of 17/17.5 Sand ST to harass, discriminate, retaliate, and threaten said landlord. Label used to simplify story. Landlord sex. Female/disabled due to hit and run by city officials. Landlord is a manager with majority ownership, 100%, but violations by law should be against X LLC, the legal owner of the property. Violations of the UCC would typically result in citations issued to the property owner, which in the case of an LLC, would be the LLC itself. Ordinances require citations to be issued to the LLC as the deeded owner and legal entity responsible for the property. Pennsylvania Uniform Construction Code, UCC. City of X Code of Ordinances, Codes, and Standards. Pennsylvania Municipalities Planning Code, MPC. Smash the like button for the YouTube algorithm. Count 2. Harassment, discrimination, retaliation, abusive communications, and threats where city's actions were motivated by bias, discrimination, or retaliation, rather than legitimate regulatory concerns, as normally tenant evictions, cleanup, and maintenance actions do not normally require condemnations to resolve them. Equal Protection Clause of the 14th Amendment. Federal and state anti-discrimination laws. Pennsylvania Human Relations Act, 43 PS Sections 951 through 963. U.S. Constitutional protections. Count 3 hit and run criminal offenses where city officials, specifically city dumpster truck hit and run against property accessory wall. Municipal liability statute for damage caused by city employees. City or its employees damaged property, e.g., an accessory wall, and failed to take responsibility and remedy situation. Pennsylvania tort law, negligence, trespass, etc. Municipal liability under the Political Subdivision Tort Claims Act. Political Subdivision Tort Claims Act, 42 Pa C.S. Sections 8541 through 8564. Criminal charges, civil penalties, license suspension, insurance consequences to offender. Count 4 hit and run criminal offense against person, landlord, for a personal injury claim under tort law involving negligence or intentional harm by a city employee. City employee caused physical injury in a hit-and-run incident where the city is liable for the employee's actions. Pennsylvania tort law, negligence, trespass, personal injury, etc. Municipal liability under the Political Subdivision Tort Claims Act. Political Subdivision Tort Claims Act, 42 Pa C.S. Sections 8541 through 8564. Criminal charges, civil penalties, license suspension, insurance consequences to offender. Count 5 hit and run to person, landlord. Personal injury claim under tort law involving negligence or intentional harm by a city employee. City employee caused physical injury in a hit-and-run incident, and the city is liable for the employee's actions. Pennsylvania tort law, personal injury. Pennsylvania tort law, negligence, trespass, etc. Municipal liability under the Political Subdivision Tort Claims Act. Political Subdivision Tort Claims Act, 42 Pa C.S. Sections 8541 through 8564. Criminal charges, civil penalties, license suspension, insurance, consequences to offender. Count 6 termination of employee with providing no resolution to landlord. Medical damages caused by hit and run by official driving truck hitting landlord where employee was terminated. Personal injury claims and wrongful termination where city attempted to distance itself from the incident by firing the responsible employee. Landlord seeks compensation for medical damages resulting from the hit and run, with possible claims against both the individual employee and the city. Tort law for personal injury. Wrongful termination under employment law. Count 7. Harassment outside jurisdiction. Claims under state or federal laws where city officials acted outside their legal jurisdiction, potentially violating due process or other rights. City officials harassed or targeted them beyond their lawful authority. State and federal constitutional protections. Civil rights claims under 42 U.S.C. Section 1983. Zoning and building codes, as outlined in Pennsylvania's Municipalities Planning Code Section 165-1 to Section 165-18. Count 8. Violation of due process rights. Plaintiff was not provided with adequate notice or an opportunity to be heard before the condemnation was issued. Violation of due process rights. U.S. Constitution, 14th Amendment. Pennsylvania Constitution, Article 1, Section 1. Zoning and building codes, as outlined in Pennsylvania's Municipalities Planning Code, i.e. Section 165-1 to Section 165-18, i.e. Section 165-6 AD, i.e. Section 617, enforcement, etc. Case law. Lindsay v. Normet, 405 U.S. 56, 1972. Landlords cannot take unilateral actions that deprive tenants of their property without following legal procedures. Count 9. Unlawful taking without just compensation. The condemnation constitutes a taking of plaintiff's property. Impacts to landlords' beneficial use of renting both units, 17/17.5 Sand Street, and condemnation, demolition, and take of 19E Oak Street without just compensation, in violation of the Fifth Amendment of the U.S. Constitution. Article 1, Section 10 of the Pennsylvania Constitution. Economic Impact and Takings Clause. Zoning and building codes, as outlined in Pennsylvania's Municipalities Planning Code. Section 165-1 to Section 165-18, i.e. Section 165-6 AD. Case law. Yickwa v. Hopkins, 118 U.S. 356, 1886. This case established that discriminatory enforcement of regulations, even if the regulations themselves are neutral, violates the Equal Protection Clause. Armstrong v. United States, 364 U.S. 40, 1960. The Supreme Court held that a property owner is entitled to just compensation if a government action effectively takes property, even if it is not a direct physical seizure. Wilson v. City of Philadelphia, 868A.2d 649, Pos CMWLTH, 2005. This case involves the condemnation process and how it impacts property owners. It outlines some of the due process requirements and could be useful in arguing that a condemnation should not unfairly impact the sale of a property. In Penn's Central Transportation Company v. New York City, 438 U.S. 104, 1978. Also case law. In Lucas v. South Carolina Coastal Council, 505 U.S. 1003, 1992. The Supreme Court ruled that if a regulation deprives a property of all economically beneficial use, it constitutes a taking that requires just compensation, highlighting issues of unjust enrichment by the state. Count 10. Arbitrary and discriminatory enforcement. The condemnation order was arbitrarily enforced against plaintiff's property, while neighboring properties in similar condition were not condemned, in violation of the Equal Protection Clause. Similar properties also had their condemnation lifted more quickly, specifically the property across the street. Equal Protection Clause of the 14th Amendment, U.S. Constitution. Fourth Amendment protects against unreasonable searches and seizures. Pennsylvania Statutory and Common Law. Pennsylvania Human Relations Act, PHRA, for understanding discriminatory enforcement practices. 2018 International Property Maintenance Code, IPMC/Residential Code. Zoning and building codes, as outlined in Pennsylvania's Municipalities Planning Code, MPC. Section 165-1 to Section 165-18, i.e. Section 165-4 clarifies dangerous buildings. Section 370-1 officials ensure that structures are safe, sanitary, and fit for occupancy and use, and the condemnation of buildings and structures unfit for human occupancy and use, always structurally safe and fit for occupancy or use. Section 186-2-3. Rehabilitation for a condemned property includes serious, significant violations. Section 165-2 Minimum health and safety requirements for buildings, structures, or properties for human occupancy. Section 165-7 Duties of Code Enforcement Officer shall include actions to provide notices in writing, state reasons for notice being issued, provide reasonable time to rectify conditions, serve notice of dangerous designation, and an outline of remedial actions shall be listed. Section 165. Part 15 to 16. Dangerous Structure and Maintenance Ordinance. Section 20. 6 Certification Part B. A property subject to condemnation has a determination of a public nuisance and is a blighted property. And Section 20 to 4. Section 248-10 clarifies violation or violations that create such a hazard to imminent threat to public health, safety, and welfare. Never applicable to property. Section 326 to 2 chronic nuisance present grave health, safety, and welfare concerns, have a tremendous negative impact upon the quality of life, safety, and health of the neighborhoods. Chronic nuisance properties are a financial burden to the city. Section 451 to 1 evidences the capacity to be habitable, landscaping maintained, utilities function, blinds exist furnished. Section 165 to 8 states, building and structures are maintained when they do not present a health and or safety hazard to surrounding properties and to the general populace. Section 248 to 6 residential rental units F. 4. Code enforcement official/inspector shall provide post-inspection report indicating full compliance or list of any deficiencies. Section 376 to 13 immunity of enforcement officers does not apply because officials failure of reasonable good faith entry upon real property for i.e. 2014 for 19 East Oak Street, i.e. February 2023 for 17 Sand Street, left unit, i.e. April 2023 for 17 Sand Street, right unit, etc. Smash the like button for the YouTube algorithm. Case law, i.e. evidence property was never of serious or significant issues to justify any condemnation. Yevons. First National Realty Corporation, 428 F.2D 1071, DCCIR 1970, established that tenants have the right to a habitable dwelling, setting a precedent that habitability depends on the property meeting certain basic living conditions. If those conditions are met, the property is considered habitable. Park West Management Corporation v. Mitchell, 391 and 8.2D 1288, New York 1979 New York Court of Appeals found that a landlord's failure to maintain the structural integrity of a building where ceiling collapses and exposed electrical wiring breached the implied warranty of habitability. Kettner v. Buckeye State Mutual Insurance Company, 2013, Ohio, 5077, Ohio Court App, 2013 Ohio Court of Appeals ruled that a property infested with bedbugs, where the landlord failed to take adequate measures to address the infestation, could be considered uninhabitable. Hilder v. St. Peter, 478A.2D 202 VT 1984, where adequate heating is important. Marini v. Ireland, 265A.2D 526, and J. 1970. New Jersey Supreme Court held landlords' responsibility to repair broken plumbing constituted a breach of the implied warranty of habitability. Johnson v. Scandia Associates Incorporated, 717A.2D 24, Con 1998 Connecticut Supreme Court held that persistent electrical issues, including frequent power outages and exposed wires, could justify a finding of uninhabitability, particularly where the landlord failed to make timely repairs. Dufum. New York City Housing Authority, 920N. Wide S.2D10 New York App, DIV 2011 Court found chronic issues with sewage backups in a public housing unit, which the Housing Authority failed to address, could render the property uninhabitable. Berman and Sons Incorporated v. Jefferson, 343 and W.2D 240, Wisconsin 1984 Wisconsin Supreme Court held that a leaky roof led to water damage and mold, breached the implied warranty of habitability, making the property uninhabitable. Green v. Superior Court, 517P.2D 1168, Cal. 1974 California Supreme Court established presence of hazardous conditions such as mold and lead paint, which were not addressed by the landlord, constituted a breach of the implied warranty of habitability. Boston Housing Authority v. Hemingway, 293 and 8.2D 831, Massachusetts 1973 Massachusetts Supreme Judicial Court recognized that lack of adequate lighting, among other issues, could render a property uninhabitable under the implied warranty of habitability. Case law, Javins v. First National Realty Corporation, 428 F.2D 1071, DCCIR 1970. This landmark case established that housing code violations that affect health and safety can breach the implied warranty of habitability. Specifically, numerous housing code violations including heating, plumbing, and sanitation. Court held that substantial violations of housing codes that affect health and safety can constitute a breach of this implied warranty. Properties are to be safe and livable. Wells versus Housing Authority of the City of Wilmington, 601S, E.2D 345, and C 2004. The court found that properties meeting local code requirements were not subject to condemnation. The U.S. Supreme Court case Goldberg versus Kelly, 397 U.S. 254, 1970, established that due process requires notice and an opportunity to be heard before a government action that could significantly affect property rights. Yikwa versus Hopkins, 118 U.S. 356, 1886, the Supreme Court held that discriminatory enforcement of regulations violates the Equal Protection Clause, even if the regulations themselves are neutral. Here, a property owner is subjected to more frequent or harsher inspections compared to others. Count 11. Impact on procedures and requirements for condemnation proceedings within the state, including providing adequate notice, an opportunity for a hearing, and fair compensation for take impacts to landlords' beneficial use, etc. Unlawful private gain for the take, if any. Lack of compensation for any take. Pennsylvania Eminent Domain Code, 26 Pascals, CS Sections 101 ET Seek. Establishes the rules for how and when property can be condemned, including requirements for notice, just compensation, and the ability to challenge a condemnation in court. Economic Impact and Takings Clause. Case Law. Penn's Central Transportation Company v. New York City, 438 U.S. 104, 1978. Also in Lucas v. South Carolina Coastal Council, 505 U.S. 1003, 1992. The Supreme Court ruled that if a regulation deprives a property of all economically beneficial use, it constitutes a taking that requires just compensation, highlighting issues of unjust enrichment by the state. Count 12. Unlawful search and seizure, where city officials conducted searches or seizures, i.e. entry onto property, inspection, seizure of items without proper warrants, probable cause, or consent, thereby violating constitutional protections. Article 1, Section 8 of the Pennsylvania Constitution, Equal Protection Clauses, 14th Amendment, U.S. Constitution. 4th Amendment to the U.S. Constitution, i.e. unreasonable searches and seizures. Count 13. Denial of permits required to rectify alleged violations. Denial of permits was both unjustified and retaliatory, preventing the plaintiff from correcting alleged violations and thereby exacerbating the situation. Due process violations under the 14th Amendment. Equal Protection Clauses, 14th Amendment, U.S. Constitution. Article 1, Section 1 of the Pennsylvania Constitution. Pennsylvania's Municipalities Planning Code, 53 PS Sections 10,101 ET Seek. Zoning and Building Codes, as outlined in Pennsylvania's Municipalities Planning Code, i.e. Section 165 to 1 to 165, 18. i.e. Subchapter C, Section 6131A, 2. Permit denials by municipality states, A. Denial, and 2. A municipality or board shall not deny a municipal permit to an applicant if the municipal permit is necessary to correct a violation of state law or a code. Case Law. Cleburne versus Cleburne Living Center, 473 U.S. 432, 1985. Cleburne denied a special use permit for a group home for the mentally disabled, although similar homes for other groups were permitted. Supreme Court found that the denial was based on irrational prejudice, violating the Equal Protection Clause. Count 14. Stop work order placed impacting landlord's ability to rectify alleged violations. Due process claims as a stop work order was issued without valid legal grounds, in an arbitrary manner, unlawfully, or as a form of harassment, hindering the ability to make necessary repairs to bring the property into compliance. Equal Protection Clauses, 14th Amendment, U.S. Constitution. Zoning and Building Codes, as outlined in Pennsylvania's Municipalities Planning Code, i.e. Section 165 to 1 to 165, 18. Subchapter C, Section 6131A, 2. Permit denials by municipality states, A. Denial, and 2. A municipality or board shall not deny a municipal permit to an applicant if the municipal permit is necessary to correct a violation of state law or a code, etc. Smash the like button for the YouTube algorithm. Count 15. Not providing occupancy certificate through unjustified delays in justice. Repeated delay of justice. When property was livable, delays were unjustified, and the property met all necessary criteria for occupancy. Due process violations under the 14th Amendment. Article 1, Section 1 of the Pennsylvania Constitution. Equal protection claims under the U.S. and Pennsylvania Constitutions. Zoning and building codes, as outlined in Pennsylvania's Municipalities Planning Code, i.e. Section 186 to 1 AG, i.e. Section 165 to 1 to Section 165, 18. Count 16. Unlawful repairs and maintenance requests unnecessary to approve occupancy certificate. Arbitrary and capricious government action, where the required repairs were not necessary for the health, safety, or welfare of occupants. Requests were either unnecessary or a pretext to delay or prevent occupancy unjustly. Zoning and building codes, as outlined in Pennsylvania's Municipalities Planning Code Section 186 to 1. Equal protection clauses, 14th Amendment, U.S. Constitution. Count 17. Unlawful significant pain and suffering due to unlawful actions of city officials. Pennsylvania tort law. Count 18. Unlawful condemnation, take, and demolition of 19E Oak Street, unconstitutional taking without just compensation. Condemnation and demolition of the property were unlawful, either because they were not properly justified, lacked due process, or were not compensated appropriately. Fifth Amendment and Article 1, Section 10 of the Pennsylvania Constitution. Due process violations under the 14th Amendment. Article 1, Section 1 of the Pennsylvania Constitution. Fifth Amendment. U.S. Constitution. Pennsylvania Eminent Domain Code, 26 Pa C. Des.
Sick.
Zoning and building codes, as outlined in Pennsylvania's Municipalities Planning Code Section 165 to 1 to Section 165, 18. Case law. Yickwa v. Hopkins, 118 U.S. 356, 1886. This case established that discriminatory enforcement of regulations, even if the regulations themselves are neutral, violates the Equal Protection Clause. Armstrong v. United States, 364 U.S. 40, 1960. The Supreme Court held that a property owner is entitled to just compensation if a government action effectively takes property, even if it is not a direct physical seizure. Wilson v. City of Philadelphia, 868A.2d 649, POS CMWLTH, 2005. This case involves the condemnation process and how it impacts property owners. It outlines some of the due process requirements and could be useful in arguing that a condemnation should not unfairly impact the sale of a property. The U.S. Supreme Court case Goldberg v. Kelly, 397 U.S. 254, 1970, established that due process requires notice and an opportunity to be heard before a government action that could significantly affect property rights. Count 19. Condemnation and demolition for public use, for economic motives and no implemented public use. Condemnation may be challenged based on lack of public purpose for 19 East Oak Street, 2014, for condemnation is only lawful if the property is taken for a public purpose. Absence of public use means designation can be challenged or overturned. Pretextual taking where improper economic motives existed. Inadequate justification includes inadequate evidence or lack of a clear plan for public use. No valid public purpose exists and property is today a blighted property city created and allowed to persist 10 years later. Eminent domain law. U.S. Constitution, Fifth Amendment. Pennsylvania Constitution, Article 1, Section 10. 26 Pascals, CS Section 204. Pennsylvania law allows property owners to challenge condemnations on the basis that the taking does not serve a legitimate public purpose. Case law. Kelo v. City of New London, 545 U.S. 469, 2005. Although this case expanded the definition of public use to include economic development, it also sparked significant controversy and led to greater scrutiny of eminent domain cases, especially where the public purpose is not immediately evident. While this U.S. Supreme Court case broadened the definition of public use, it also highlighted the need for a valid public purpose to justify condemnation. Count 20 inverse condemnation of 17/17.5 Sand Street and or 19E Oak Street, 2014. Inverse condemnation occurs when a government action effectively takes property without formal condemnation proceedings or compensation. This could be argued if the condemnation results in significant devaluation of the property, loss of beneficial use, or prevents its sale without following proper legal procedures. 26 Pascals, CS Section 502, allows property owners to seek compensation through an inverse condemnation claim where property has been effectively taken without proper condemnation proceedings. Fifth Amendment of the U.S. Constitution. Article 1, Section 10 of the Pennsylvania Constitution. Pennsylvania's Eminent Domain Code, 26 Pa Cs.
Isaac.
Case law. Yickwa v. Hopkins, 118 U.S. 356, 1886. This case established that discriminatory enforcement of regulations, even if the regulations themselves are neutral, violates the Equal Protection Clause. Armstrong v. United States, 364 U.S. 40, 1960. The Supreme Court held that a property owner is entitled to just compensation if a government action effectively takes property, even if it is not a direct physical seizure. Wilson v. City of Philadelphia, 868A.2d 649, Pa CMWLTH, 2005. This case involves the condemnation process and how it impacts property owners. It outlines some of the due process requirements and could be useful in arguing that a condemnation should not unfairly impact the sale of a property. The U.S. Supreme Court case Goldberg v. Kelly, 397 U.S. 254, 1970, established that due process requires notice and an opportunity to be heard before a government action that could significantly affect property rights. Count 21 Impacts to Accepted Sale Offer, July 2024. Financial and contractual damages suffered by the property owner due to the actions or inactions of the city, which impacted an accepted sale offer for the property in July 2024. Delays to lifting of a condemnation order. City's failure to act within a reasonable timeframe or its mishandling of the condemnation process direct impact on sale. Tortious interference with contractual relations. Third party, through wrongful conduct, intentionally interferes with an existing contract, causing one party to breach the contract or rendering it impossible for the contract to be fulfilled. City's unjustifiable delay or refusal to lift a condemnation or provide necessary certifications directly interfered with the ability to complete the sale, causing financial harm. Pennsylvania Common Law. Restatement, 2nd, of Tort Section 766 for Pennsylvania for tortious interference with contracts. Inverse condemnation. Pennsylvania's common law principles of negligence. City's negligence or improper conduct led to the failure of the sale. This could form the basis of a claim for damages. Pennsylvania's Municipalities Planning Code, 53 PS Sections 10,101 ET Seek. For breach of duty, city had a legal duty to act in a certain manner, e.g., issuing permits, providing necessary inspections or certifications, and failed to do so, causing the sale to fall through. The property owner could argue a breach of duty that resulted in financial harm. City was required to take certain actions, such as inspecting the property or lifting a condemnation designation, and failed to do so. This inaction could be seen as a breach of their legal duty, which directly impacted the sale. Restatement, 2nd, of Tort Section 766. Provides the legal framework for tortious interference with a contract, which may apply if the city's actions were intentional and led to the failure of the sale. Case law. Pennsylvania Coal Company v. Mahone, 260 U.S. 393, 1922 established the principle that while the government can regulate property, if the regulation goes too far, it will be recognized as a taking, for which compensation must be provided. Wilson v. City of Philadelphia, 868A.2d 649, Pa Commonwealth, 2005, This case involves the condemnation process and how it impacts property owners. It outlines some of the due process requirements and could be useful in arguing that a condemnation should not unfairly impact the sale of a property. Armstrong v. United States, 364 U.S. 40, 1960. The Supreme Court held that a property owner is entitled to just compensation if a government action effectively takes property, even if it is not a direct physical seizure. Count 22. Attempted 17/17.5 Sand Street, and achieved unjust enrichment, 19, East Oak Street, where one party benefits at the expense of another in a manner deemed unjust by law. City retained control over the property without just compensation. Pennsylvania's common law. Pennsylvania Eminent Domain Code, 26 Pa Cs.
Isaac.
Pennsylvania Municipalities Planning Code, 53 PS Sections 10,101 ET Seek. Zoning and Building Codes, as outlined in Pennsylvania's Municipalities Planning Code. Case law. Urban Redevelopment Authority of Pittsburgh, 913A.2D 178, PA 2006, asterisk. Condemnation case emphasizes the importance of providing adequate compensation to property owners whose properties are condemned. While not directly about habitability, it touches on issues of fairness and just compensation, which could be relevant when a condemnation affects a property's sale. Armstrong versus United States, 364 U.S. 40. 1960, the Supreme Court held that a property owner is entitled to just compensation if a government action effectively takes property, even if it is not a direct physical seizure. Count 23. City mayor and city attorney willfully allowed unlawful actions. Landlord and city officials' email correspondence have city attorney CC'd. Attorney willfully allowed unlawful actions against landlord and failed to advise officials against illegal actions, raising ethical concerns for the attorney. When actions violate ordinances, laws, or regulations, the responsible party could face penalties, fines, or other legal consequences. An attorney who knowingly participates in or fails to correct unlawful actions is subject to disciplinary actions from the state bar or other professional consequences. When willful higher penalties, allegations of bad faith, or additional legal scrutiny applies. Similarly, city mayor was notified of issues February 2024 and CC'd on emails to report concerns for resolution. Pennsylvania Rules of Professional Conduct. Pennsylvania Crimes Code, Title 18. Pennsylvania Uniform Construction Code, UCC. Application of International Property Maintenance Code, IPMC. Application of Pennsylvania Municipalities Planning Code, MPC. Count 24. Officials harasses landlord about boarding house and bed and breakfast citations, which landlord never violated. Landlord always maintains a single-family dwelling for both units and never a boarding house, bed and breakfast. Airbnb website platform use to find single-family tenants is also not prohibited by law. Landlord never provides meals or shared facilities. Instead, the tenants have the entire apartment to themselves. Zoning and building codes, as outlined in Pennsylvania's Municipalities Planning Code. Section 480.41 and Section 480.42. A. The property is encouraged for use as and may be utilized for permitted use of single-family dwelling. See definitions. Thank you for the support. I greatly appreciate all. Very respectfully, Alyssa.
Signature.
Some are born great, some achieve greatness, and some have greatness thrust upon them. Shakespeare. Trust is the glue of life. It's the most essential ingredient in effective communication. It's the foundational principle that holds all relationships. Stephen Covey. By law, one may file a claim or appeal against a condemnation designation if it has not been lifted and is impacting the sale of your property. Specifically, here landlord lost sale August 1st, 2024. Not all inclusively. Here we list grounds for filing a lawsuit. Due process violations. Condemnation process, violated due process rights, etc., which includes a lack of proper notice, failure to follow legal procedures, or denial of the opportunity to challenge the condemnation before it was finalized. Unreasonable delay in lifting condemnation. If the condemnation designation was not lifted within a reasonable time after the issues were resolved, you could claim that the delay is causing unnecessary harm, particularly if it is impacting the sale of your property. Economic damages. Compensation for economic damages caused by the inability to sell the property. This could include lost profits, loss of use damages, and additional costs incurred due to the delay. Arbitrary or discriminatory enforcement. If similar properties were not condemned or had their condemnation lifted more quickly, you might argue that the enforcement against your property was arbitrary or discriminatory, violating the Equal Protection Clause. Legal process. File an appeal or claim. Depending on your jurisdiction, you can file an appeal with the local or state government agency responsible for the condemnation, or you might file a lawsuit in civil court. Seek an injunction. You can request a court to issue an injunction requiring the government to lift the condemnation designation if it is determined to be unjustified. Case law examples. Armstrong versus United States, 364 U.S. 40. 1960, the Supreme Court held that a property owner is entitled to just compensation if a government action effectively takes property, even if it is not a direct physical seizure. Yikwa versus Hopkins, 118 U.S. 356. 1886, this case established that discriminatory enforcement of regulations, even if the regulations themselves are neutral, violates the Equal Protection Clause. Asterisk in recondemnation by the Urban Redevelopment Authority of Pittsburgh, 913A.2D 178, PA 2006, asterisk. This case emphasizes the importance of providing adequate compensation to property owners whose properties are condemned. While not directly about habitability, it touches on issues of fairness and just compensation, which could be relevant when a condemnation affects a property's sale. Inference here, precedent clarifies habitability and condemnation are not the same thing. Landlord City treats habitability and condemnation as the same thing based on August 20th, 2024 court proceedings transcripts evidencing such. Asterisk Wilson v. City of Philadelphia, 868A.2D 649, PA Commonwealth. 2005, asterisk. This case involves the condemnation process and how it impacts property owners. It outlines some of the due process requirements and could be useful in arguing that a condemnation should not unfairly impact the sale of a property. Level up your life. Follow us on Medium to unlock our secrets. Subscribe to us on YouTube. My repair, maintenance, labor, dumpster, labor costs reimbursement which cause pain and suffering. Landlord repair, maintenance, labor, dumpster, labor costs reimbursement. Official stolen trespassing and beware of dog signs, $35. Landlord shall not by law be required to pay for services never utilized and services never received. Reimbursement for city unlawfully backdated charges, $430 plus $630 for trash removal services. See May 18, 2023, 10:08. Reimbursement of sewage costs when property was in condemned, not habitable designation May 2022 to August 19, 2024, where due cost maximum was legally $15 maximum per month, or similar number. Officials' retaliatory actions led to unfair higher amounts paid that legally required by law. City dumpster hit and run damages to accessory wall repairs reimbursement. Impact on property sale. Damages for the loss of sign sale offer $230,000 plus closing costs $20,000. Medical surgeries, therapy appointments, and other issues. Physical and mental health impact. Hit and run, therapy ongoing appointments, surgeries i.e. fractured toe, shoulder, and knee issues of disabled landlord. Loss of quality of life due to significant stress, mental anguish, non-economic damages, and or economic impacts i.e. financial undue hardship. Impacts due to harassment, discrimination, retaliation, threats, etc. Pain and suffering. Emotional distress, anxiety, suicidal. Family impacts, divorce. Chronic stress. Hypothermia, loss of feeling in extremities due to exterior painting and landscaping in freezing temperatures and wind chill regardless of disability of landowner. Working on the list, but difficult because owner is disabled and your list requires playing with dirt, stones, and scrubbing siding in sub 32-degree temps and snow. Punitive damages for bad faith actions, hit and run actions, and etc. Attorney's fees and costs, if any. Legal filing fees, Luzerne County. A filing, PACF file, etc. Any other relief available based on the facts of the case. End of damages. In addition to the above, other sections of the civil suit include finding a form or cover page that you must fill out. This section asks for you to fill out what the case is about. Here a cover sheet asks you to fill out name, whether tort, contract, civil appeal, mass tort, real property, miscellaneous, or professional liability applies to your case. Are you requesting damages? Are you filing a class action suit? Interestingly, earlier in this article I clarified that our local clerks and protonotaries stated they would not answer questions. In alignment with what I said above, the cover sheet specifically states, Notice Rule 205.5. Cover sheet Pennsylvania Rule of Civil Procedure 205.5. Cover sheet provides, in part, C. The protonotary shall assist a party appearing pro se in the completion of the form. This means they must literally help you fill out the form by law, which they specifically say they will not do. Further evidence of due process for this landlord. Also, B. States you are required to fill out a cover sheet. This makes sense, of course. Of course, you pay filing fees and submit a cover sheet to process your case. Your cover sheet will be published to www.pawcourts.us. D. Speaks to an electronic filing system for maintaining files. Smash the like button for the YouTube algorithm. Yes, Mafia rules apply. Never were landlord or I provided details about submitting evidence to the e-file system for the hearing August 20th, 2024, and I only learned of it when talking to the Pennsylvania Superior Court clerk who clarified the PAC file electronic filing system. Looks like the lower-level courts withhold information unlawfully, which leads to unfair hearings and the inability to be fairly heard. Unfair hearing processes. Good luck getting a fair outcome when Mafia rules apply.
Continuing on.
Yes, a cover sheet is required. A facts background section will clarify important facts for the case, all numbered in an organized way. Basically, the entire case should have a table of contents or similar numbering, because start to finish of your case will be numbered 1 to 100 hypothetically. Then, for example, for the exhibit section, you may have a numbering label of E6.1, E6.2, E6.3, E6.4, etc. Exhibits here are in hypothetical section 6, then each attachment is numbered in an increasing ascending way. Other needed sections for the lawsuit include sections for A. Chronological timeline of events. Witness lists with name, phone number, email, address, and why they are relevant to case. Requested discovery. Admissions of facts. Conclusions of law which are both defendant and plaintiff agreed upon. Finally, you must provide a verification statement which you sign and date that verifies authenticity of the submission and actions to provide documents to the judge and other party. I am not an attorney, so this is just information that is generally applicable but may vary with state, locality, or processes. When it comes to all this, it is not easy, and you are disadvantaged if you do all this alone. Even if you have an attorney, that does not mean the attorney will not exceed what you can afford, then become not affordable later in the case. So often people start having an attorney, then are forced to end representation with their attorney because they are no longer affordable. This means, before you start a process, ensure you are willing to finish it alone. An attorney may only want to get paid. They may not finish the suit if you can't pay them. This fact is why I recommend you find attorneys on contingency. If an attorney is not willing to take on a case in contingency, they probably do not know the law well enough to assure you win. Attorneys only offer to take you on in contingency when the facts are overwhelmingly winnable, and they have to be good at what they do to have this level of confidence. Why go into a process if you are not overwhelmingly sure the case is winnable? I do not waste my time unless the issue at hand is serious and significant. I also do not think it is wise to pay an attorney because costs are often exorbitant. More importantly, if an attorney is worth their salt, they will be so sure about the case facts, legalities of it all, and case law that they take on the costs of filing the lawsuit knowing they will surely win. I only get like this, passionate and upset when issues at hand are serious and significant. Attorneys should be willing to pursue cases with their own money on the line when the facts are all overwhelmingly in their favor, especially if they are good at what they do. This is why I say, do not waste your time unless issues are significant or serious. Lawsuits are a waste of life and often not fair. Furthermore, I would only pursue a case if an attorney takes you on contingency. This is where they charge you nothing and take a percentage of the damages when the case is won. You do not have to win all issues, claims, or counts. Instead, you only need to win one to technically win the case. Of course, the more claims or counts won, the better. The other side will do their best to get everything dropped. Also expect the other side to file motions to get a summary judgment in their favor, which is basically them asking the judge to drop some or all claims before going to hearing or trial. When you receive one, try not to freak out. You have a right to be heard, especially on important issues to your case. Here it is very important you or your attorney lays out good reason as to why the motion should be dismissed in part or in full. Comment level up. To show you are ready to level up, comment below. Do you have questions about this process? What do you think about finding attorneys and filing suits? Do you agree legal processes are unfair? Do you agree processes are a waste of life? Do you agree the little guy always gets taken advantage of? Usually on purpose, otherwise unintentionally. Feel free to clarify your story about these processes in the chat below. I would love to hear your opinion on all this and get a debate going in the chat. Yes, I have a strong opinion. I have a pretty interdisciplinary knowledge base on environmental law, tax law, some criminal law, some real estate law, and employment law. I have seen some pretty upsetting adversity, so yes, that leads to strong opinions. Sorry if you disagree. I love hearing both sides of all stories, but my opinion may not be easy to be swayed because it may take some amazingly ethical outcomes to erase the wrongful observations of the past which persist in my mind. Thank you for reviewing all this to the end. Smash the like button for the YouTube algorithm. Smash the like button for the YouTube algorithm to supercharge the YouTube algorithm and support me making more content for you. Subscribe by clicking on my on-screen photo. We will help you level up your successes and foster the best outcomes in life.
Just gotta flip the switch and you can go and obtain anything you want, anything you need. Your mind's got the key ingredients, believe me. Even when you feel low, you can still go. Even when you feel slow, you can still go.